Welcome back to one more session. Today in this session I'm going to discuss about the writ of certiorari. A writ of certiorari is issued by a superior court, either Supreme Court or High Courts, to an inferior court or body exercising judicial or quasi-judicial functions to remove a suit from such inferior court or body and adjudicate upon the validity of the proceedings, or body exercising judicial or quasi-judicial functions. The fundamental principles in regard to the issuing of a writ of certiorari is that the writ can be availed of only to remove or to adjudicate upon the validity of judicial acts. The expression judicial acts includes the exercise of quasi-judicial functions and is used in contrast which have purely ministerial acts. There is a case law with respect to this writ of certiorari. There are so many cases, but in one of the important case, that province of Bombay versus Kushal Das, AIR 1950 SC 22. In this case, the Supreme Court has laid down two propositions for ascertaining whether an authority is to act judicially. In that, one, if a statute empowers an authority to decide disputes arising out of a claim made by one party under the statute, which claim is opposed by another party, then prima facie and in the absence of anything in the statute to the contrary, it is the duty of the authority to act judicially, and the decision of the authority is a quasi-judicial act. This is the one proposition which is given by the Supreme Court. And another one, if a statutory authority has power to do any act which will prejudicially affect the subject, then although there are not two parties apart from the authority and the contest is between the authority proposing to do the act and the subject opposing it, the final determination of the authority will be a quasi-judicial act, provided the authority is required by the statute to act judicially. This is the proposition which is given by the Supreme Court in this particular case. Grounds on which writ can be issued. The writ of certiorari can be issued under the following grounds. The writ of certiorari is issued to a judicial or quasi-judicial body on the following grounds. 1. Where there is want of excess jurisdiction, where there is error of law apparent on the face of the record but not error of a fact. And third one, where there is a violation of procedure or disregards of principles of natural justice. Under these grounds, the writ of certiorari can be issued. The important note that a writ of certiorari cannot be issued against a private body, and it is not maintainable against such a private person, society, body, or any institution. So simply, writ of certiorari cannot be issued against the private body. If we try to apply, then also it cannot be maintainable. This is about writ of certiorari. Thank you.